Welcome, legal eagles and true crime fanatics. Ever wonder what really goes down in a courtroom? We're about to dive headfirst into some intense legal drama, fresh from the judge's bench. From questionable car tags to a staggering list of open cases, prepare for some jaw-dropping moments and critical legal insights. You won't believe what some people try to get away with, and how the law reels them back in.
Morning, Mr. Huddleston. Sir, you're charged with tampering with a government record. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you, sir.
On February 16th, officers observed a vehicle with a temporary tag which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and had been pulled over the week prior. The defendant stated his mom went to the dealership and bought a new buyer's tag for the car. The defendant did not know how much the new tag was bought for.
So why does Mr. Huddleston get charged then? Oh, it's pled differently. It's pled differently. That's why. Let's see. It's pled here as use as opposed to purchasing. And I think that that's why. So let me see.
And I did notice it showed up as tampering of the record insurance document, but it looks like on the complaint it is tampering of the record.
Hereinafter style the defendant heretofore February 16th did then and there unlawfully, intentionally, and knowingly use a governmental record, namely Texas temporary tag attached hereto as Exhibit A with knowledge of its falsity. So one of the parts is it says with knowledge of its falsity.
Yes, Judge.
Does he know of its falsity?
Well, upon the officer approaching the vehicle,
Okay.
he knew immediately what the traffic stop was for. That he'd been pulled over the week prior to this, but
He had been
yes.
and advised that it was no good. Read it one more time.
Officers observed the vehicle with a temporary tag which came back with no return. A traffic stop was conducted. The defendant was the driver and sole occupant. The defendant stated he knew about the tag and had been pulled over for the week.
Right. Okay. All right. Mr. Huddleston, I'm going to find that there's probable cause to go forward with your case. Can you run his license? See if he has a valid Texas license, please. I am ordering you as a condition of your bond, sir, not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
These are your bond conditions, meaning that if you don't follow these bond conditions, a warrant for your arrest will be issued. You will go to jail. No more PR bonds.
Hold up. Did you catch that? Not only is this individual facing new charges, but he's already on felony probation. That's like being on thin ice, and he just jumped into a bonfire. The judge's warning about a warrant for his arrest is no idle threat. This new charge could trigger a probation violation, sending him straight back to jail without a bond. It's a tough situation, and you have to wonder what's going through his mind right now, facing such serious consequences.
What's more is you are on felony probation. You've now picked up a new case. Best be on the lookout. It's very possible that they now issue a warrant on you.
His license is valid, Judge.
So you mind filing that then? No driving with that, both, please. Tell me, Mr. Huddleston, do you have the ability to hire a lawyer? No. I'll have you fill out an application. I'll take a look to see whether you qualify. All right? Do not leave until you sign our bond conditions. You understand? Come on. Mr. McGee, I mean, I don't even know what happened, but I'm in shock, man. You're on deferred for an unauthorized use of a motor vehicle. Since January, you picked up a failure to ID, an evading arrest, 2 theft cases, another evading arrest, another UUMV, and another burglary of a motor vehicle. So we have
Excuse
Hold
me,
on.
sorry.
We're going to do probable. I have no idea what happened. We'll do probable cause on all of them because I have no idea. All I know is that you've got 1, 2, 3, 4, 5, 6, 7, 8 open cases. So let's do this. I see. So far from January 23rd of this year, he had a failure to ID evading. We've already done probable cause. It's been found that there's a bond set. It looks like February 14th, a felony theft was picked up. A bond has been set on that case. Probable cause has been found. Now, as of 2:15, the next day, you picked up a theft, evading arrest, another unauthorized use, and a burglary of a motor vehicle. So we're going to do probable cause on all those cases. You have the right to remain silent. Anything you say can or will be used against you. So I guess, can you start with the theft?
Yes.
So in this case, you're facing up to 6 months in jail and or a $2,000 fine.
On February 14th, 2025, officers were dispatched to
6955 Sam Houston Freeway regarding a shoplifter. The call note stated that a black male wearing blue jeans and a brown jacket was inside the store concealing items. The officer observed the defendant walking outside the location and through the parking lot. The officer attempted to make contact with the defendant, who then began to flee on foot. The defendant ran through the parking lot, maneuvering through motor vehicles. The officer was then able to catch up with the defendant and attempted to tackle the defendant to the ground. The defendant was able to slip away and continue to evade. The officer was able to tackle the defendant to the ground, but was still attempting to stand back up and get away. So the officer struck him one more time to gain compliance, and he evaded for approximately 50 yards.
Where was that theft from?
Target, Your Honor.
All right, so I'll find probable cause on both of those cases. So then we have now a burglary of a motor vehicle from 2/19/25. What happened then?
On December 25th, 2024, officers were dispatched for an abandoned stolen vehicle at the Cypress Park and Ride. The officer reviewed surveillance footage taken from December 25th, 2025, and observed the complainant's vehicle. The officer identified a black male wearing a hoodie, blue jeans, and brown boots entering the vehicle. The officer immediately recognized and identified the defendant, identified as Zyron McGee, also known as Zion Williams, from a previous case at the same location. The defendant in the video, he then broke the window and got into the vehicle. The complainant did not give the defendant permission to be in the vehicle and was missing a jacket and a charging cord.
Did you say all that was on video too?
Yes, on the surveillance.
The other thing you said it happened December 20
5th, yes.
of 25 or 24?
24.
So it seems, okay. So I'll find there's probable cause to go forward there. So we need to set bonds on these cases. What should we set them at?
Well, of course, defendant is 18 years old, judge, no job. Are you in school?
No, man, I'm about to go back to school. They, two of my schools didn't allow me because of my charges of the summertime in 2024, and they denied me school.
What grade are you in?
I'm supposed to be 12th grade. I'm supposed to be graduating this year.
I see one thing. That's what I see.
Yes, sir. But
It's the only thing I see.
yes, sir.
No. The problem is, well, you have to remain silent. You will have the opportunity to fight these cases. But the problem is, when we let you out, you pick up a case. It's like you're your own worst enemy, dude. Really? Who do you have in your life? Who's there for you? Who do you have?
Yeah, only people I got in my life is my big sister and my brothers and stuff, but we all separated type stuff. I keep trying to keep in touch. I'm trying to keep in contact with them. Other than that, on a day-to-day basis, I have two friends that I stay with, and I accompany my friend's father. You feel me? I accompany him on a day-to-day basis. So just, you feel me?
Mr. McGee, you have to make a change before you get killed. You live in Texas, man. People like their guns and they like their cars. And I cannot tell you how many people get shot at and killed because they break into the...
Just listen to them.
I'm listening to this. Can you talk? Yes, sir.
You're trying to think of things to say and you're not listening. I'm trying to give you pointers in life because the problem is you've probably never had someone in your life to tell you, hey man, straighten up and fly right before you land your ass in prison for the next 20 years.
This is a powerful moment. The judge isn't just laying down the law, she's offering a tough dose of reality and a plea for change. She's highlighting a critical issue in the justice system, how to break the cycle of reoffending, especially for young individuals who might lack stable support systems. Her words about straightening up and flying right before ending up in prison for decades are stark, but they come from a place of experience and a genuine desire to prevent a tragic outcome. It's a crucial reminder that the courtroom is not just about punishment, but sometimes about intervention.
Yes, sir.
Don't thank me. Don't, you think that this is a game, and it's not a game, Mr. McGee. You've got 8 open cases now, and the problem is that you cannot use your circumstances to the criminality, meaning that I know that you may have had a hard lot in life. We are now here to help you, and I will try to help you in every way that I can. But the problem is that if I let you out, I think that you're going to listen to me. I don't think that you're going to do what you're supposed to do. So something's got to give. Either you're going to get a lengthy prison sentence, you're going to grow up in there with probably the wrong people trying to guide you. When you're out there in the free world, if you need help, we can always help you here. All you got to do is ask. But when you're given a bad lot in life, you can still raise up and persevere. It's just how you go about doing it. You understand?
Yes, sir.
You've dug yourself a hole, but it's not so damn deep that you can't get out of. Someday you will, but you have to turn around because something's got to give. You're either going to get a lengthy jail sentence or you're going to end up dead. People like their guns and they like their cars. And when you mess with the wrong person, they're going to shoot your ass dead. And I can show you article after article after article where someone ends up dead because they break another wrong person's car. I have it here. Once every 2 weeks, someone's dead because of it. I would not let you out unless I know that you have a stable and trusting place to go to. Not a friend, not Mr. McGee. You need time. This isn't something that we just make here on a 2-second whim. I want to give you guys time to talk about circumstance, how things go. Right now, I'm going to set the bonds all at 5,000 and I guess 5,008 because he has 8 cases open. You also have to understand one more thing. You probably don't have anyone in this life that's going to bond you out when you pick up criminal cases. So when you're out there in the free world and you're thinking of things, if I do this, could this land me in custody? Because if it does, you ain't got no one that's going to get you out. That's what you got to think about. You understand?
Yes, sir.
I don't want you to have any contact with any of the people, any of the places, complaining witnesses, no weapons. If you get out, I'm going to give you a leg monitor so I know where you are at all times. I don't know if that's going to happen now, but we need to find something. Something's got to change because what's happening now is just not working. And I'm not going to let you go. Somehow we're going to work this thing out one way or the other. So I guess let's set it a week and then see what you can to find something stable. And then just let me know. If you can, we'll talk and we'll think. The problem is you still have the felony cases upstairs. Even if whatever we do, you still have a $20,000 bond on the felony theft. Is that a stolen car case?
The MJ case was a stolen car. I don't know if the more recent one.
No, there's another 2,500.
Yes, Your Honor. It was out of the same transaction as the most one, it looks like. So yes, it was a stolen vehicle.
Can I make it a bond condition that he doesn't go near any cars?
Your Honor, the state would be requesting
Can't breathe
yes,
the
they
air.
would do.
Yeah, well, obviously, but the problem is I don't know where, to have a curfew, you need a place to go to. So that's one of the issues that we have, right?
I think it's on my list.
It really sucks, man. It really does. I wish that things were different. Start listening to people who care, because that's the only way you're going to start getting help around here. Eventually you'll get out. If you ever need anything, we have cell phones, tablets, places for you to go, to eat. You want a job? I can get you a job. We have damn near anything that you could possibly want. All you have to do is ask. 5,008 on all the ones that don't have bonds now. Guys, hey, I don't want you to talk here because we got a whole audience here. It's not good. We'll get you back there talking.
Thank you, Judge.
We'll work it one way or the other, but you're your own worst enemy, my friend.
Yes, sir.
It's got to stop.
I will.
Okay.
Thank you, Judge.
Thank you. Yes. Mr. Wilson, you were charged with theft. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford, one will be appointed to you, sir.
On August 18th, 2023, complaining witness saw the defendant enter the store, which was a Dick's Sporting Goods, and try on a pair of sunglasses and then request to try on a pair of shoes. The defendant tried on the shoes and placed them back to the box and continued to browse. He then selected a pair of socks and then put the socks and the shoes on and exited the aisle and made no attempt to take the merchandise. The total value of the goods was $185. Officers reviewed the video and confirmed that there was no attempt made to pick the goods. The complaining witness was able to recognize the defendant from one of his prior booking photos using a photo.
What does that mean, prior booking photos from?
Are you asking for what?
I'm guessing he has a prior theft at the same place.
He does have a prior theft, Judge.
Does he have any open cases right now?
No, Judge, just this theft. The previous theft was from a different store.
Mr. Wilson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now not to go to any Dick's Sporting Goods at all, anywhere. Do you understand? I'm going to protect everyone in my city and everything. If I find that you become a danger, I only have one place for you. Do you understand?
Mm-hmm.
That's not an answer.
So,
Better. You have this air of arrogance to you, Mr. Wilson, but you're now here. Really? Do you have the ability to hire a lawyer? Okay. We're going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, sir. Mr. Shaw, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford, one will be appointed to you, sir.
On February 12th, officers observed the defendant's motor vehicle bearing a paper Texas tag. And an NCIC, TCIC search of the tag came back with no result, so a traffic stop was initiated. Officers made contact with the defendant. Defendant said that he purchased the motor vehicle approximately 2 months ago for $2,000 from a mutual acquaintance, but did not have title to the vehicle and did not have insurance or proof of financial responsibility, and that he purchased the tag from a separate mutual acquaintance for $80. The defendant stated that the paper tag was not affixed to the rear of the motor vehicle he purchased, and that he purchased the tag separately until he could have the motor vehicle registered.
Mr. Shaw, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
yes.
You will be signing an affidavit with me today, which is a promise that you're going to make to me that you're not going to drive without either. If you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
Citation on both sides. Okay. Mr. Shaw, do you have the ability to hire a lawyer? I will take a look at an application. I need you to fill it out for me. I need to know everything about you, what kind of car you drive, how much money you have in the bank, how much money you make. I'll take a look to see whether you qualify.
Yes, sir.
For now, I'm going to have you also sign this affidavit that you're not to drive without insurance as well.